We're live.
All right, good morning. It is January 21st, Senate Judiciary. We're dealing with S-209. We'll be having a discussion and markup. We also do have two witnesses that we want to hear from. But before we move into the discussion and markup, just so we can have a little bit more information to inform us as we enter that. So I see that Reverend Sparrow is on the Zoom. And are you able to hear us?
Yes, I can.
Fantastic. So I know you're here to talk about S-209. I want to give you the floor if you just want to introduce yourself and share what you'd like to share about the bill. That would be great.
Okay, thank you very much for inviting me. I'd also like to say that I had hoped to bring Susan McMillan, who's a deacon of the Episcopal Church, but she's on her way to Minneapolis for a clergy call. I just introduce myself. I was a pastor of a church in Guilford, Vermont for 20 years, and I'm now retired, and now I'm working with Vermont Interfaith Action and on the Justice and Witness Ministries for the United Church of Christ. So I've been involved in these issues for a long time, and another activity that I have is I work with refugees here in southern Vermont, two families in particular, but I'm working to develop a network of clergy for support all over the state. So these are issues which are dear and near to my heart. And I really appreciate your consideration of including churches and faith communities in this bill. I really have two different angles that I'd like to present, and I'll do that briefly. I'm respectful of your time, and I appreciate this testimonial aspect of the process. The first is that I understand in the bill, we're talking about sensitive locations. And I'm not exactly sure what that means, but I'm just going to offer that in Brattleboro alone or in Windham County, most churches have one or more of the following ministries. That would be child care centers. There are 4 child care centers in churches. One of our homeless shelters, the one for the most vulnerable, is in a church. 3 have food shelves, and there are a couple of thrift shops, not to mention the kind of counseling that always goes on in churches. So if we were just to sit with me not knowing what sensitive location means, I would encourage you to think about the fact that the most vulnerable members of our communities often go to churches, whether or not they are members of those communities, and are particularly vulnerable. Most of them have had some sort of trauma or are vulnerable to trauma. So the idea of unexpected violence and detainment in those places is doubly concerning. So I would offer that just out of the gate. As I dug into this more, though, I want to recognize that I'm 75 years old, so I have lived through different versions of churches being sanctuaries, and I wanted to talk about that probably more importantly. I realize that when you say something is a sensitive location, that doesn't necessarily her back to the First Amendment, but I want to make sure that you understand that the First Amendment protects the freedom of religion, and it does, and guards against the government having the power to control or destroy religious institutions. And with those institutions, our ability to live out our faith. So in my faith tradition alone, the first one that I can think of is the Amistad ship, which came into Connecticut. And I think many of you know about this, that protected a shipload of slaves for some months until they could be given their freedom. And what that meant right then, and then I'll talk a little bit more about some of the other cases, is that as long as those slaves were in the church building, then due process could continue and until they left. So there was a lot of effort by members of the church community, guided by their faith, to make sure that those people could remain safe. In my lifetime, I saw that happen when I was in college for the draft resistors against the Vietnam War, is that draft resistors would take sanctuary in churches until due process could happen and they could go to wherever they were going or have their cases adjudicated. More recently, I was aware of a situation in Amherst, Massachusetts, where a man who was seeking asylum lived for almost 2 years with the help of church members until he could be granted asylum. And some of you may also know, if you know Southern Vermont, that Weston Priory also gave sanctuary to a Guatemalan family who were in danger and waiting for their asylum. So there's a lot of precedent about churches being able to live out their faith by providing sanctuary within their buildings. So I, I really feel that that's the bigger question here. It's this idea of a First Amendment right. A secondary part of that, which I'd like you to consider, is which is that the churches cannot be taxed. And for those of you who are lawyers, and I expect you all are lawyers, the underlying belief of churches not being taxed is that if churches could be taxed, then they could have the power to basically destroy churches through taxation. And our founding fathers basically believed that people should be able to worship without government interference. So again, I'm encouraging you to think about the fact that for us to live out our faith, we need buildings and we need to live out our faith within those buildings. I understand that outside the buildings, the government can do whatever they want. So this leads me to one last comment, which is that currently, for those of you who are churchgoers, you will know this, but for those of you who aren't, the ACLU has guided churches on sanctuary by helping us understand what we can do within our buildings. And I want to say I'm already disturbed at this, because what it's meant is that all of us have worked together to define spaces within our buildings that are private and that cannot be entered without a warrant. I believe that we should be able to carry out whatever we do within the buildings without anyone coming in without a warrant. So at this point, it's as if the buildings have been constrained now, so that most churches have a designated area with a sign that says privacy, and that if someone is in there, then the ICE agents need to go and get a warrant. That's a very extreme thing for churches to have to do. And it also means that ICE agents can come in while we are worshiping, and I'm sure you saw the news about them having done that, to restrain someone. So I guess I have concerns on many levels, but I'll just summarize, which is one, is that our churches are places for vulnerable people, and that we are living out our faith by providing them support. And that any hindrance to that is really keeping us from living out our faith, which is protected by the First Amendment. The second is the history of churches, and that means the buildings being sanctuaries. And the third is this recent diminishment of what is defined as safe space within churches to just be a space that we put a sign on. So all these are my concerns. Thank you very much for your time. Happy to answer questions, but I'm sure you have a lot to do.
Thank you. Committee, any questions for Reverend Sparrow? Okay, great. Thank you for testifying. It's good to see you, and
Likewise.
I'm sure I'll see you around.
Yeah, thank you all very much for all your work.
Have a nice day.
You too.
Next up, we have Charlie. You wanted to testify and provide some input as well, I think.
Yeah, thank you so much.
Yeah.
Let's change.
Thank you so much. Good morning, Charlie Winterman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I appreciate the opportunity to speak briefly on S209. We appreciate the committee's consideration of the bill and would request the addition of social services establishments like domestic and sexual violence organizations to the list of sensitive locations. As you've discussed in previous testimony, the Department of Homeland Security had longstanding guidance that ICE refrain from enforcement actions in sensitive locations. In 2021, social services establishments were added to that list that was then rescinded in 2025 and resulted in concern and a real lack of clarity for providers. Domestic and sexual violence organizations provide life-saving services like shelter, legal support, safety planning, and more. This work is highly sensitive and it often occurs during the most dangerous periods of a survivor's life. So when a survivor seeks support, it's really an act of trust. Trust that they seeking help will be safer than remaining in an abusive partner's relationship or in an unsafe home. Survivors already face many barriers to seeking safety. And so regardless of their real or perceived immigration status, they shouldn't face an additional barrier to accessing support, like the fear that they could expose themselves or their families to enforcement actions. 9 out of our 14 member programs do provide community-based shelter, but even among those, many have offices that are not co-located with their community-based shelter, which is currently named in the bill. So services like support groups, confidential one-on-one support, free legal clinics are often in those office-based settings, not currently included in the bill. Including social services establishments in the list of sensitive locations would offer clarity and consistency to survivors and the providers who serve them. And we've included the relevant language previously in the Department of Homeland Security guidance on social services establishments in our written testimony in case it's helpful reference to the committee. We appreciate your committee's attention to this issue. I'd be happy to answer any questions.
Thank you. I think my first question, is there a definition of social services establishments anywhere that you know of that we could cross-reference? Anything along those lines?
So I took a quick look through Vermont statutes. I didn't find anything that was as comprehensive as the social services establishment definition that was included in the previous Department of Homeland Security guidance. And so I have included that definition in my written testimony. When I think about what would be most helpful to providers, I think of the practices that they've established and followed over the last 4 years under this guidance, and that feels the most appropriate from our perspective for a definition.
Seems reasonable to make the most of previous existing federal definition.
Any questions, Charlotte? Yeah, great. Thank you.
Thank you very much.
Right. You want to read those? Thank you. So with that testimony and also prior testimony in mind, I think we can enter a discussion / markup phase for this bill. Unlike yesterday, I think we'll just start from the top and go to the bottom so we're all over the place. So any initial discussion that we want to have about this general point or specific for us?
I'm just always worried about slippery wording and tightening it up as much as possible. Community-based shelter. I'm wondering about your definition of that. I'm assuming it's like a warming shelter or an overnight shelter. But I could see it being outside. So I'm wondering what our definition is.
So, Rick Sable, for the Office of Legislative Counsel. Senator Bruce, what you see, is maybe something different from someone else's sees. So that's a problem that we don't have that defined. I think overall, when you're talking about arresting people, you want to be really clear so police can do their job.
Yeah.
And so they can follow the law, especially since you have remedies here. The AG could possibly, sue if this law is violated. So I tend to agree that if we can cross-reference something, we can be more specific, or it can just be detailed in the definition itself here on this page. We should do so. I do have the Charlie was talking about the previous DHS guidance. I have that document pulled up if you want to see how it defined social services, community-based shelter.
That would be
Okay.
okay.
Yeah. 1 second here. This was a policy that was in place and it started late 2021. And pretty early in President Trump's second term, it was rescinded. So let me show you the top of the page. So this is a DHS memorandum, not an executive order, not a law, but advice from the head of DHS at the time. You scroll down. So, and actually I was going to share this anyway because they define this as protected areas. This bill defines it as sensitive spaces. Kind of means the same thing. And I think last time the committee talked about putting some findings in to kind of support the law. And this order may give you some ideas on how you want to word those findings, because it does talk about the reasons why they instituted this policy. So I'm going to skip down to the second bullet point there. A social services establishment, such as a crisis center, domestic violence shelter, victim service center, and I'll let you read the rest of it there. So maybe this is what you thought of when you read community-based shelter. Maybe it's more broad, or I can't imagine it'd be less than we thought it was, but it's fairly comprehensive, and we want to be sure that we include what you want to include.
Yeah. I think there are a lot of good specifics in that second bullet point that I'm seeing, where it starts social services establishment and so on. I think the only thing that could be too vague is a community-based organization, because you can make the argument that anything under the sun is a community-based organization. And I know we want to get a bit more specific, but Senator Hosty.
I wonder if it also might make sense to use the Department of Children and Families definition of community-based shelter, which is a community-based shelter is defined as a facility or program that provides temporary short-term shelter to individuals and families experiencing homelessness, which meets the specific standards set out by the Department of Children and Families or the Vermont Housing Opportunities Grant. We've referenced that in other legislation. I mean, I'm really happy to do whatever. I just figured I would bring up that we do have a definition of that.
And it's for community-based shelters?
Yes.
Okay.
Yes.
So
That makes sense to me. This list, and maybe I'm misunderstanding the relationships, but this is put out by DHS to guide its own agents in how they do their job. So it seems like they're less concerned with slippage in definitions maybe than we would be, because this has been rescinded and we're now up against the government that opposes those definitions. So I think we have to be extra careful about making sure that our definitions are specific. So I think the one that Senator Wilson just talked about, we should definitely add. I do wonder if the broader we make this list, whether we are weakening protections overall. In other words, right now, it has court proceeding, which we did, and we heard testimony that has worked, that people are not being arrested on the way to from a court proceeding. But I do wonder if we expand the list too far, if we make it more likely that the list will be ignored. You know what I'm saying?
sort of.
Well, in other words, if you look at this, if we were to take this whole list, it seems to me to be covering a huge amount of ground and space within a community that might look like more like a sanctuary city than sensitive locations in a town list. So I just think it's a balancing act. Myself.
I just ask you a clarifying question. So for this definition of, of social service organization, were you suggesting that it made sense if we struck community-based service organization because that's too vague?
That, yeah, so I guess it's essentially markup for that one piece here, in subsection D, so that's where we're at. So yeah, I think the definition that we're seeing in that second bullet point, minus the very broad community-based organization phrase, but adding what you found from DCF regarding the shelters would make sense. But also, I don't want to forget, how do we, well, does it look like, well, trying to make sure that matches what was raised by Charlie regarding the domestic violence shelters and the other pieces. So I think perhaps replacing, or yeah, I think adding that second bullet point, taking away community-based organization, but adding the GCF definition for
Community-based shelter.
I think that could make sense.
Okay, sorry, I just want to make sure. So we're going to,
Hold on, what did Charlie did?
My apologies. There was just one piece of language that I wanted to clarify. Domestic violence shelter. There are a few of our member programs who I noted do not have a shelter. They are a domestic violence organization. And so if there's an opportunity to address that in any revised language, that would be appreciated.
would this next thing get it with the victim service center?
There are many different kinds of victim services organizations. For example, victims that are serving victims of centers that are serving victims of elder abuse. I think that because across so many areas of Vermont statute, we talk about domestic and sexual violence organizations, that it might just be clarifying to have that language here.
So can I go back to try to clarify? So you're suggesting we replace D with this definition minus community-based organizations with the addition of domestic and sexual violence. And then in a definition section, define community-based shelter with the DCF definition.
Probably.
I'm the only one that's confused.
No, I think that you're on the right path. I think though I also. All right, let me rephrase. I think for the purposes of markup, if we strike out the word or phrase community-based shelter and then add essentially that entire second bullet point and take out community-based organization while also keeping severe weather shelter or emergency housing provided for 33 BSA, which is in the current draft that we have. And so and then adding the other section that defines emergency housing, was it? No.
Community-based shelter. So
Community-based
community-based shelter would need to get added to this list. And then we would define it.
Got it. Okay.
I was
I'm
just
tracking now.
I was just new subdivision for that. It's gonna be pretty unwieldy if you
Yeah.
add in this and then say community-based shelter as defined. It's still gonna be in front. You probably didn't hear that, but just so it'll be easier to read. Because it's gonna be pretty lengthy.
So yeah, I figured it may get subdivided, but it's fine. I think further to clarification, and I think Senator's point earlier, the last clause essentially of other essentials of life to people in need is another. Yeah, I get it, but it is a pretty broad and vague phrase. And so I don't know if we could include that.
But is it, DCF, is it community-based shelter or?
That is the language
Okay,
that
all right.
is community-based shelter is defined.
I should be able to find it, but email to me, that'd be great as well.
Okay, if you try. And then the other piece I'm hearing from Charlie is to add specific reference to domestic and sexual violence services, because we define that in state law all over the place. To the social service organizations list.
Yeah.
Yes.
What are committee's thoughts on that and what we've heard so far?
I think what's being laid out is fine.
Sarah Norris, any thoughts
Well, I have a lot of thoughts on this.
on that particular fee? So
I guess do whatever you deem necessary. That's my thought.
How are you feeling about the overall concept?
You know, well, I asked the question, another section of the law. The overall concept is, when I look at these places, I'm saying, okay, the courts are already in there. I agree with that. The schools, definitely, I don't see a need for anybody to go with the K-8 or whatever else to traumatize our kind of students. Hospitals, I agree with that. And I don't feel comfortable with the state, county, or municipal buildings. It appears as though we take the state of Vermont, go to each township. It appears in my mind as we're setting up little bunkers at each township for protection. And along with that, you know, the governor has already said that, responded twice to this present administration in Vermont is not a sanctuary state as far as funding is concerned. And I think, you know, the pendulum's starting to swing depending on what we do with this particular situation. And I do have a large concern about individuals being allowed to take court proceedings against someone, but more importantly, on page 3, line 12, maybe Rick can explain to me exactly what that means. When it says on behalf of the state, what does that mean exactly, Rick?
Well, because the AG is, you know, the chief lawyer of the state anyway, it's just stating that if you violate this law, it is a, you know, violation of state law, and the AG is going to defend the state law. And you can sue for damages or injunctive relief, or won't be damages, but injunctive relief, basically stop the arrest at that specific location. That's
Existing statute.
yes.
So I think if we're able to go back to the page 2 and resume the discussion and markup of these particular exceptions or prohibitions, I think we got the community-based shelter piece down. We can start back at the top, which would also get to Senator Norris's point about the state, county, municipal buildings. Do we have thoughts, concerns, or suggestions regarding that particular section
Well,
from the committee or?
it's reminding me of the discussion we had about prohibiting firearms in state, county, municipal buildings. And one of the things that hung it up was that those buildings are not just the courthouse, whatever. There's Alice Mitchell's always on about the salt shed. You know, the salt shed is a municipal building. So I suppose somebody could critique it in that way, that it winds up including a lot of buildings that people might not think of as central municipal buildings. Personally, I would like them not to be able to arrest in any of these locations. So I'm happy to vote for a bill, you know, a version that contains more rather than less. I'm just cautioning around specific language and wondering if we make the list too long, too complete, whether we will wind up unintentionally weaken the provision by stretching some funds.
Yeah, I mean, so some of the things that I was thinking about was what we heard from Reverend Sparrow, but also some of the points that were raised at the top of the document that's on the screen now about why civil arrest shouldn't happen in these different types of areas. Whether it's schools, and Senator Norris said, traumatizing these kids, or healthcare facilities or churches and so on. And so, there are different populations that go in there with different needs and different vulnerabilities, whereas state or county or municipal buildings, it could be the salt shed or almost anywhere. So, yes, good points on both sides of it. Senator Lowe's.
I appreciate that it might include the salt shed. I don't know. I mean, I don't even know where my municipal or county salt sheds are. So I don't know that people are going to necessarily be going to visit the salt shed. But when I think about state, county, or municipal buildings, if one has to go to those, they have to go to them. They're going to renew their driver's license. They're going to pay their taxes. They're going to do something that they don't have a choice but to do. And that's where, as I think about this, yes, there are places like schools where we've got children, but I'm also really thinking about what are the things someone doesn't have a choice but to do. And that is where, the state, county, and municipal buildings came in for me. Was generally speaking, if someone is visiting one of these places, they have to, in order to participate in their life.
And to add to that, I don't know if it would hold water legally, but to me, it feels like if you're talking about state, county, or municipal buildings, because we're asserting our rights as a state when we do this. So it seems like if it's going to be valid anywhere, it would be in our buildings or our county buildings.
And I do know of other states. So I think I may have said this on the record, or maybe I said this in passing at this point. I don't know who I've said what to. But I know Colorado has passed language that covers some of the similar things to what's on this list. And I believe Tennessee has a bill introduced. So we're not the only state to either be doing this, contemplating this, and in some instances, some states are ahead of us in actually passing language like this.
Rick, any legal advice for us?
Speak just to subdivision B, something I thought about just in the last 10-15 minutes is what about corrections, jails? So I know Vermont does house some federal detainees. Would that be an issue? Because we have an MOU, I believe, with the feds on holding detainees who have already undergone that civil arrest. So I don't know if that needs to be accepted or discussed. You may want to have a Department of Corrections efficient in here. It's
definitely be valuable to have corrections come in. My question, though, is simply a process question. If someone has already been arrested and is being detained, why would they be civilly arrested again while in that location?
I'm thinking it's a good question. My thinking is just, would that be a way for that person to, would their lawyer be able to argue, well, this person is currently under civil arrest.
Right.
He or she is remaining at a jail owned by a state, and this is against state law. So this person is in this jail. I'm just kind of maybe overthinking, but I could wonder.
Yeah, I can see a situation where somebody gets arrested criminally, let's just say the DUI, or well, actually something where they'll get held right after getting arrested. So aggravated assault and they're in jail, and it ends up somehow on ICE's radar, and but they go in. Would this prohibit them from going in and saying, "Hey, you have to go in for an immigration hearing now in a month," or what? I could see challenges logistically in that.
But if they had a judicial warrant, they could still do that. Like, this doesn't prohibit civil arrest entirely. It prohibits it without warrant.
Right, civil arrest typically there's no difference, or there's administrative warrants. Yeah, but as the chair was indicating, if they may just have probable cause, which still require warrants, to assume this person is remaining here without documents, so this person should be deported or should be held pending deportation proceedings. So that would, I think, be complex and this under this statute if it were to pass as per. So I think definitely hearing corrections about that would be good.
Yeah. All right, so we can put an asterisk next to that and revisit it and Emery, if you don't mind to just make a note that when we do agenda planning tomorrow, we'll reach out to DOC and see that. Thank you.
So I was wondering if we could get a side by side, I'm supposed to be mentioning Colorado and all the other state. Tennessee.
So
Their laws.
I know some states have introduced, like Pennsylvania has like 1,000 feet within a state facility. There's like very degrees of extent. I'm not familiar with the state that's passed a law that includes a list like Vermont has suggested here. Some states have, like New York has Professor Bowman Posen, trigger on I talked about New York executive order. So that's an executive order. It's not passed by their assembly. I can show you side by side of that. It includes state facilities. It does not include schools, hospitals, or churches.
No, I'd like to see a side by side of those states that have actually passed laws that pertain to this one here.
Not just court proceedings, but because some states do have court proceedings, but you want to see side by side with other similar.
If you could, please.
Yeah, I'll see what there is. There's not a whole lot that have expanded this yet, but I can look and see.
I will dig through my copious notes and information and try to get you what I have on Colorado and Tennessee and maybe California. Like I said, Tennessee's has.
Illinois recently did something, there's varying degrees of this, but they're not as comprehensive as we do.
I think that covers that section for now. If I put an asterisk next to it, you come back.
Did we end the definition of school?
Yes, that is interesting.
Oh, okay. I thought you were done with the whole section,
No,
not.
no, just
Okay.
me. So schools, I know that is a definition that we'll want to figure out because, again, quite broad, and I suspect there are definitions of the 2200 series and could help have Beth St. James come in and testify to that. Any initial thoughts, Rick?
I think I may have mentioned last time, just want to hear from the committee what you want to include, and that will help even that come in and give you all definitions.
Yeah, I mean, my first thought on it, the way I envision it playing out is, when I think of schools, I'm thinking of daycare centers, public schools, private schools, after school programs. The places where kids are generally congregating throughout the day for educational purposes or after school purposes, which are generally educational. So,
Given the most on the Dowie things where he is a college student, I'm wondering, should schools include campuses, college campuses?
yeah, that's a good question. I'm not opposed to that.
And I know some of these things, I hate to keep making an analogy to gun laws, but I know a number of these locations have been defined for a long time in our gun laws. And schools as it exists, the gun laws doesn't include childcare centers, which I was amazed when I found out. And further amazed that a lot of people argue that childcare centers shouldn't should be able to bring a gun into a childcare center. But I am often amazed by the findings.
Committee, any other thoughts or opinions on this?
So I have no idea if it was some or around. And also, the only thing I would add is when you say private schools, does that include independent schools or?
Yeah, that-
Call that.
I meant independent schools.
I just wasn't sure if those were analogous terms or if they were two different
Pretty,
things. Okay.
any additional thoughts? There matters, anything?
Right now,
Yeah, I was listening in on the way down and I think the Senator Norris's point about broadening it so far. And then the Senator Bruin's point about if you broaden it so far, like the federal government at the list,
right,
you stop paying attention to the list. And by broadening it out so far with different things, and I think locations rather, and agreeing with Senator Norris on, schools, hospitals, the courts that it's already in law. I'm supportive of. It's just broadening and now college campuses. What does that encompass? That like vast. There's a lot of different university-owned, college-owned property, not just in one central area. So it's definitely gonna, I'm open to learning more and figuring out what falls into what category. But if we expand it so far, it's not going to be worth, I don't think, what we want it to be.
Yeah, it would be good to hear from some universities and colleges in the state. I do. Well, I don't want to speculate about grants and funding from the federal government that may affect our college and university campuses. So have them speak to that.
And is it directed at? It's civil arrest, so it's not just directed at immigration.
Correct. It is raw. It includes any enforcement within our state that would include local and state and deputies, and it would incidentally affect the federal government.
Yeah. And just like one other thing, I don't think we've gotten to it yet, but just kind of that definition around traveling to, entering, remaining at, returning from. Like, what does that encompass? Because I could leave my house at 8 o'clock for a 2 o'clock court proceeding, but I got to go to the grocery store and other things. Is that?
Yeah, I think in a sidebar initially with Rick prior to the committee starting, that was brought up as something that we should discuss a bit further. I know it can be complicated. And Rick, actually, if you want to chime in now on that piece, and then we can go to Senator Holtz's question.
Sure. And sure, I do have a 10 o'clock house come off, so I can maybe stay a little bit longer, but just as an FYI.
Yeah.
So yeah, I read that, and I think again the law just applies out of courts, right? And I think that makes some sense, and that's pretty clear. If you're traveling to a courthouse, but you have a date, some kind of hearings, some kind of appearance in court. But if we expand it to government buildings, schools, even schools make some sense. You're on a school bus, like there's some definite times you're going and leaving school. But going to a hospital, going to town hall, that to me as a police officer, it gets complicated.
Yeah.
And as I've said before, if you want to enforce this, it needs to be clear what's wrong, what's not wrong. So, and I think if you're going to expand this, we need to clean up that definition. Not needed to remove it all, but we need to kind of set parameters. What is entering? What is leaving? What's returning? Remaining that we know what that is. But yeah, I think it's a good point that it's certainly broad. You're trying to enforce it.
Right. Just like with 208, I want to make sure that whatever legislation that we do is actually something that we can do. Not just words on a piece of paper to say we did something, but actually be actionable. I was taught in school, actions speak louder than words. So I want to make sure that it can be done.
So this is not my original question. This is in response to this. I know that we have similar language in our Good Samaritan laws about traveling to and from, so I wonder if this may already be defined in statute. I don't know. I haven't had a chance to look it up, but I do know that that language includes traveling to and from. It was also included in our language around drug checking facilities. So it could already be defined. It might be worth taking a look. My question, was around, it's actually circling back to schools. And wondering if there is a distinction between, universities, and you might have to walk with me a minute on my thinking process here, between our state universities like UVM and the Vermont State Colleges that receive state money and fully private universities. I don't know that would apply within our K-12 system because private schools are part of the ecosystem. And they are receiving public money, so I don't know, because I know that we've had some conversation about not being able to tell fully private entities. So do you travel with my train of thought here?
Yeah, I do. My first answer is I don't know. My second answer is a private school is not open to the public, right? So I think about that, and also private schools for kids as well as private universities. So, can a officer, either federal or state, go into a private university without a search warrant or an arrest warrant? They could get consent, right, from the administrator, and that would remove any of this, but,
When again, it's tricky in the K-12 system because we have
Sure.
independent schools that are actively getting.
right, I don't want to speak, I let that same
Oh,
speak,
maybe
but universities to me is also, the funding is different for me, but it is a private location, which my state should not be doing that anyway, or should state police, if they don't have a warrant to go into a private location.
Yeah,
Something
I
to
just,
think about, these are already public places, that's something we're limiting here. When we talk about private, places that are not open to the public, that should be off limits to police without a warrant already.
I think we should have that. And it just, as I was thinking about it, I was just sort of thinking about the different K-12 sort of ecosystem as pertains to private schools versus the
Right.
university system, whereas the state colleges and UVM, they're getting public money.
I'm gonna defer to that same thing, but
That's fair.
other question.
And so I know you only have a couple minutes left.
And actually, Emery, if you want to email, is it Nick in-house GovOps?
Yes.
If let him know, I can push it. I think if we need to finish up here, that's fine. Okay.
Yeah, I think, maybe just another 5 minutes or so, I think that would suffice, and then just want to give people a chance to use the bathroom, so, maybe 10:10 we'll pick up the Prop 4, that works for you, Julio, is that? Sure. So we had also heard about, I think healthcare facilities, that seems all set in terms of whether or not it's, how it's defined. I don't know that we have to dive too deep into that necessarily, but I guess it does warrant the question of how the committee feels about it. Generally being on that list of prohibitions, I'm supportive of it. Any other thoughts on it?
I support it. Obviously, as I put it.
I know there's still the lingering question of differences between traveling to and from versus attending a certain place, and I think that applies. That's a conversation that applies to all of these, to one extent or another. So I think that is another piece that we'll have to revisit. Churches and places of worship. Were we, any thoughts on what we heard earlier, Rick? Definitions?
I think that type of location is an easier sell constitutionally because of the First Amendment freedom of religion. The argument is that you go to church to exercise a First Amendment right to exercise your religion. And I think that's a clearer path, honestly.
I absolutely support adding this. I'm just wondering if the definition either in state or federal law anywhere of what a church or house of worship is.
I'm sure there is. I can bring some, I think the next time for your consideration.
So I certainly support this, but I don't know what that definition is, and I certainly know sometimes there are nefarious things happening under the guise of religion that's really more cult-like practices. And I just want to make sure we define what we're talking about.
Yeah, so do you want to give me any parameters?
No, I'm curious what exists.
Yeah.
I'm generally of the opinion that we don't need to recreate the wheel if the wheel exists and it's round and working.
So I don't know that we can necessarily cover the final point in 5 minutes, but perhaps some stuff to think about regarding the remedies. Did you have any points that you wanted to share with us regarding that section? Because I know it right now it's only applying it, the language is for courthouses, which exists currently. Do you have any closing thoughts for us that we can think about and then revisit in the next conversation?
So on page 3, line 6, under subdivision A, something I didn't catch last time is, again, this law is written to apply to the courthouses. And the first remedy is a person who violates that subsection by taking away somebody under civil arrest is subject to a contempt proceeding and may be liable in a civil action for false imprisonment. The civil action is fine, but the contempt proceeding would apply to a court where you're in contempt because you're disobeying a court order. So just to clean that up, if you're going to add more sensitive locations, you want to not just call it contempt. You want to either remove that or, if in courthouse contempt. So that's the only other issue I have, legally speaking, in the remedy section.
I think it could be worthwhile just getting an initial draft that kind of separates the two, and then revisiting it conversation later. Sarah, if I will see.
I seem to recall that the ACLU was going to potentially, they had some thoughts about this and making it somewhat more defensible. And I had asked them to maybe get us some language, but I'm happy to circle back with them and maybe find a time to meet with you, Rick, to dial that in if that is helpful.
Yeah.
Okay. Okay, we'll figure out a time to connect with you.
Anything else regarding that section or generally? Rick, do you have any final points needed to raise?
Looking at my questions from last time, and the professor answered some of the questions about what a person is. I think she answered that via her email. He asked about the history of having General Assembly members free from arrest. That's more of a U.S. Constitution thing that Vermont brought over. Is U.S. House members and Senate members are also privileged from arrest when they are doing their work in DC. So Vermont just brought that over. So Vermont representatives are also protected from arrest. That was just a question you had. I think otherwise, the list of places is what is needs to be fleshed out the most. And I have my orders from the committee. I think I'm clear. Great.
So there's no arrest for civil arrest. Just a matter of if someone allegedly violates this section, the individual who bring charges or they need for charges.
My understanding at the moment, yeah.
No criminal record, no criminal.
No civil tickets.
No civil tickets.
Does local law enforcement going to become involved at any point in time during this interaction?
As far as enforcing,
Yes.
no.
I just saw my own notes on Colorado. There are a lot of schools and healthcare facilities.
And that passed.
That is my understanding, but I'm still a little bit more.
You could be right. Things move quickly.
Yeah.
Things change.
All right, great, thank you.
Yeah.
Rick. Committee will take 5 minutes and be back by 10:10 and we can switch to prop board.